I filed my appeal brief this morning. Excuse me. So, so I thought it would be the end of September, but I paid my final fee for the lower court yesterday to produce the case file for the appellate court, and when they said they'd probably be done by September 19th, and as soon as I paid it, like 2 hours later, it was a surprise, we're done. And it coincided with when I was finishing my brief. I tend to work compulsively on something, and until it's done. In this case, something that it moves me to work on it, and then when it's done, I can't have it. It's got to go. I gotta file it. There's no, and of course I know it's done because when I'm going to sleep and my mind's going over everything, and waking up in the morning, same thing, and having a cup of coffee, and then I was down to, well, I got to capitalize this letter and change the order of these two words, and really down to almost nothing. So I finished it, and I shut it off. You file it. I mean, I'm in Mexico, and this is one great thing about it now. You can do this as remote work even. So I'm watching. There's Mexico. These are Mexican. There's two manuals. One is a pro se guide produced by the Florida Bar Association for the appeal process, and the other is the Florida procedures, appellate procedures, whatever you say. I'm watching again Eric Klopper's Sex and Circumcision, an American Love Story. And it just occurred to me, because I was doing this thing on the, in my paperwork, the American Academy of Pediatrics did not renew their last statement on circumcision. They last 5 years and they automatically expire. And then, in my brief, I quote their 1971 statement, which is there was no medical indication for circumcision in the neonatal period. Period. Full stop. And I was watching Eric Klopper here, and I'm thinking his play was, I think, 2018, about the time the AAP's last statement expired. And I'm thinking, well, he might be the reason why they did not renew it. I think they're trying to, at this point, very slowly back away, because they are just about to get their head bit off. In fact, there is a suit against them, Levine, Lavine versus American Academy of Pediatrics. That's on the website circumcisionisafraud.com. And so that's it. That's it. Now, the firm that was representing the hospital, it was an outside firm, they switched lawyers for the appellate process. I just got that email an hour ago. And I already told the first lawyer, I sued him for $25 million. I think that they're a public hospital and have legislative protection beyond $200,000. So pay the $200,000 and no non-disclosure or anything like that. Write it up and we'll be done with it. Then the hospital can say to parents, can't do it. Risk management won't allow us because it's going to become costly. $200,000 is their absolute best case scenario. And so we'll see what this appellate is going to come. You know, this is an exercise in the arrangement of words, and I'm in this context anyway. Break anybody on the wheel that talk out the side of their neck about this shit. The judge dismissed the case insufficiency of outrage. It's an intentional infliction of emotional distress case. There's 4 elements to the tort in Florida law. And he did it, and he said, that's a matter of law. He says, it's not a matter of fact, because the judge decides the law and the jury decides the fact. But it was just him trying to do something by decree, and acting like this judicial oligarchy. And because the state and federal constitutions guarantee right to trial, it is inviolate, cannot be violated. And where he got this thing about a matter of law. Now there were some quirky cases that were cited. I mean, one lady I think was on a commercial airplane and commercial jet, and the pilot had to shut down one of the engines because get some bad readings. And I've not been on a jet like that before, and just, if he didn't tell people, you wouldn't know. It landed normal. And so she filed intentional infliction of emotional distress, which intentional is also reckless. And I'm not sure that if you have to say negligent, because there's also negligent infliction of emotional distress, or they're all under the same umbrella. But and then there was another case that one got dismissed for that same reason. Insufficiency of outrage. Anyway, one of the other cases was somebody, I don't forget exactly the relationship, but somebody was banging on somebody's door late at night, and they come out there and asked him to keep on trucking, and I don't know, he went out to the street, and then he came back and banged it again. They called the police, and the police came and told the guy to, scram. I forget the details, but anyway, it was that brief of an occasion. It was the homeowners, whoever was now sued, whoever it was, just banging on their door for intentional infliction of emotional distress. It's not funny. I mean, but those, you could understand how the definition of the tort, these elements of the tort, that the average person wouldn't go, this just can't, we can't let this pass. This person has to, no. So you can understand that. Or there's a lot of this hanky-panky in the office where a woman will be put upon by her boss if she rejects some advancement and they keep it up. And there was one of those cases where that was dismissed for insufficiency of outrage, because it's pretty common, for guys under the influence of testosterone to do that kind of bird dogging. But in another case, the guy was a real ass, and he was finally started putting his hands on the girl, and I forget the details, but that threw the court over the edge, and that case, I think she won. We went to trial anyway. And then there were even, and then there were other situations that were certainly quite stressful for the plaintiff who decided to sue. Really, you can only imagine. One of them was, and it's an insurance company. This guy's wife's dying, and she's on his policy. He has some kind of business, and they gave him and one court had already told the insurance company, pay according to the plan, and they still had this relationship full of animosity and wouldn't pay. And so And that case was weird because you can imagine how stressful that is. They wouldn't let, he had other causes of action, so he got reimbursed. His wife passed away, which was inevitable. I mean, it was an Alzheimer's case, but the infliction of emotional distress was, unnecessary, and so I thought he should have won that case, but they didn't let him because the insurance company had a legal right to do what they did, because there was some question about whether Medicare would cover her, which they already knew they wouldn't, and so the husband didn't do the paperwork involved to prove that Medicare wouldn't cover her, and so I think the court let the insurance company off on that point, because can't remember them. That was an exception to it. Even though if it was really, seemed rude, let's say, if there was a legal allowance to behave the way that they behaved, then it would be dismissed on that count, on intentional infliction of emotional distress. So I guess I'm kind of tired right now, so I'm going slow. So I guess I said all I wanted to say. If you watch that play, I was just showing, my computer went to sleep. Hang on. It's free on YouTube, 2 hours and 10 minutes. And so if you watch this play, you will certainly understand that it's outrageous. I mean, oh my God, it's so outrageous. Whew. And so this is what the judge said. It's a matter of law, insufficiency of outrage, and granted the defense motion to dismiss. Well, first of all, you have inviolate right to trial by jury, and second of all, in this restatement, second of whatever it is, number 46 in the Florida law, they talk about this. It goes back to that thing about a recitation of the facts to an average member of the community would fail to get that response. The person would become immediately as frustrated as the plaintiff in hearing the story, and just exclaim outrageous or indicate in some other way. Well, but the idea in my brief is that, I have an inviolate right. I'm the one that recites the facts. The average members of the community are the jury. And when I recite this, I use all the modifiers and justifications of the dead, but I get bring exhibits and expert witnesses and all this. In fact, Eric Klopper's play is on my exhibits list. We didn't get that far in the trial, but the one good thing about that was that not knowing how to do it exactly, because I'm not a lawyer, I'm representing myself pro se. The exhibits list was due, and I sent it in, and the defense counsel didn't send theirs in. I said, "How come y'all didn't send it in?" She said, "Oh well, we were changing judges. 2 judges recused themselves, and so it was without the assigned judge that said those deadlines were not, in effect." So I'm like, all right. I mean, that didn't bother me. But the thing is, when and the judge in the hearing to the motion to dismiss didn't look at any of the evidence. He didn't look at any of the evidence or exhibits. It wasn't required to at that point. But when I filed the appeal, you send up all the paperwork that was part of the case file before the. I'm almost done here. Before the final order from the lower court. So the exhibits list was in there. So the appellate court may in fact have to look at it. But all I asked them to do was remand the case for further proceedings. And because there's going to be a fight, you know. They are not fighting me right now. They're dodging me. And by God, they get in the ring and that's it. It's all over. Now that's Lake Chapala in the Jalisco state of Mexico, south of, about 30 minutes south of Guadalajara, at least from the airport.